Module 4. Families and Social Security Benefits. Investment News, an online publication and one of the country's leading news sources for financial advisors and investment strategists, has recently seen an uptick in inquiries from readers who ask about whether their grandchildren and other relatives can collect Social Security benefits. Like many other things in Social Security, which consists of over 2,700 rules, the answer is it depends. The Social Security system is viewed as a dual-purpose system. The main purpose is for retirees themselves to receive benefits. But the other purpose is to protect family members, such as spouses, surviving dependents, and children, who may also qualify for benefits based on a breadwinner's earnings. In this module, we will survey the array of benefits available to a breadwinner's family members and discuss which family members can qualify for Social Security benefits. Family maximum for Social Security benefits. While a worker and her family can be eligible for Social Security benefits, one cannot simply add up everyone's potential benefits to calculate the total amount of benefits that a family can collect. The Social Security Administration imposes a limit on benefits that can go to a family called the family maximum, which is based on the worker's earnings record. The family maximum in the case of disability benefits is no more than 150% of the disabled worker's full retirement benefit. For retirement and survivor benefits, the family maximum may be as high as 188% of the worker's full retirement benefit. If the family maximum is exceeded, the benefits earmarked for dependents of the worker, but not those for the worker herself, are reduced proportionately to avoid exceeding the family maximum for the household. For example, assume a retired breadwinner dies and leaves behind a widow who has reached full retirement age, as well as two elderly parents who depend on him for more than half of their support. Without the family maximum, the widow would qualify for 100% of the full retirement benefits, and each elderly parent could qualify for 75% of the full retirement benefit. Adding all that comes to 250% of the deceased worker's full retirement benefit. The family maximum reduces those benefits proportionately, so that the total adds up to no more than 188% of the deceased's full benefit. Children and Social Security benefits. Natural and adopted children, as well as stepchildren, can be eligible for Social Security's old age, survivors, and disability insurance benefits. The purpose of providing a child with such benefits is to replace the lost financial support due to the parent's disability or death. The Social Security Administration will consider a person a child's parent if the person is the mother or father as defined by applicable state law. Eligible children includes grandchildren and even step-grandchildren. Social Security pays more benefits to children than any other federal government program. In 2018, more than 4 million children qualified for their own Social Security benefits as dependents of breadwinners who have retired, passed away, or become disabled. The same year, the Social Security Administration distributed an average of $2.6 billion monthly to these child beneficiaries. An unmarried child living with a parent who is disabled, or retired, or who lived with a parent who died after having worked long enough in a job where she paid Social Security taxes, can get benefits if 1. The child is younger than 18 years of age, or 2. The child is 18 or 19 years old and a full-time high school student, or 3. The child is 18 or older with a disability that began before he reached the age of 22. For example, assume a 62-year-old parent has a 14-year-old child, and that the parent's primary insurance amount would be $2,000 at full retirement age. She could wait the 5 years to collect $2,000 a month at full retirement age, or she can immediately receive lower benefits, closer to $1,500 per month. But if she chose the immediate benefits, the child would receive about $1,000 per month, until the child reaches the age cutoff of 18 years old. This amounts to a total of $2,500 a month for the family for the next 4 years until the child reaches age 18, though that would then decrease to $1,500 a month when the child comes of age. A growing number of American grandparents have grandchildren who live in their households. Grandchildren and even step-grandchildren may be eligible for Social Security benefits. To be eligible as a dependent for Social Security benefits, it's not enough for the grandchild to live with and be dependent upon the grandparent. To receive these Social Security benefits, all of the following must apply. 1. The child's natural biological parents must be deceased or disabled, or the grandparent must legally adopt the child. 2. The child must have begun living with the grandparent before age 18. 3. The child must have received at least 1/2 of his support from the grandparent for the year before the month that the grandparent became entitled to retirement or disability insurance benefits or died. And 4. The child's natural biological parents must not be making regular contributions to the child's support. Spouses and Social Security benefits. According to a CNBC study, one of the most prevalent myths regarding Social Security is, my marital status doesn't affect my decision of when to take my benefits. Spousal benefits do not reduce Social Security benefits that a breadwinner is entitled to, and this status can even boost the income of a household if both spouses are alive. Spousal benefits are designed to provide retirement income to a spouse who either didn't work or earned significantly less than her spouse over a working lifetime, and these benefits are available even if one spouse has never worked. For a spouse to receive a worker's benefits, the spouse claiming the spousal benefits must be age 62 or older, and the spouse claiming the spousal benefits must file for benefits simultaneously with or after the worker spouse has filed for his or her benefits. Spousal benefits allow someone with low or no Social Security benefits allowances to instead receive an amount that is equal to 50% of the spouse's primary insurance amount, which is the benefit calculated as of the spouse's full retirement age. However, under a 2015 law that affects people born in 1954 or later, by applying for spousal benefits, the applicant chooses to forego her own Social Security benefits. People affected by this law cannot, for example, take spousal benefits until age 70 and then take her own benefits calculated as of her retirement at age 70. Moreover, applying for spousal benefits when younger than full retirement age causes a decrease in benefits that's the same proportionate decrease as suffered by people who choose to receive early retirement benefits. So, for example, if a spouse takes spousal benefits at age 62, when the full retirement age is 67, the spousal benefit amount will be reduced by about 1/3 of what she'd be eligible for at age 67. In effect, instead of being entitled to 50% of her spouse's benefits, calculated under the assumption that he'd retire at full retirement age, she'd get only 32.5% of her spouse's benefit amount. If a spouse waits until full retirement age, that amount comes to 50% of the breadwinner's full payment. Let's look at an example. Stephen and Eliza are married. Stephen is 67 years old and Eliza is 62. Stephen is eligible for a benefit if he retires at full retirement age of $2,400 monthly, and Eliza would be eligible for a benefit of $900 when she receives full retirement age based on her own employment history. So, she should probably choose spousal benefits over her own benefits, as 50% of her spouse's primary insurance amount is more than her primary insurance amount. However, she can only get a spousal benefit if Stephen also applies, rather than, for example, waiting until age 70. Let's assume Stephen does apply. Eliza can now also apply for spousal benefits. She is entitled to a spousal benefit equal to 32.5% of Stephen's $2,400 primary insurance amount, or $780. This, of course, is in addition to the full $2,400 that Stephen is entitled to. Eliza could, instead, delay until she reaches full retirement age before filing for spousal benefits, which would then give her a spousal benefit of 50% of Stephen's monthly retirement benefits, or a total of $1,200. This is the same choice as faced by those entitled to retirement benefits under their own work records. Unlike the basic retirement benefit, which increases up to age 70 if a retiree doesn't claim it at full retirement age, spousal benefits do not increase after the spouse reaches full retirement age. 50% of the spouse's primary insurance amount is a hard cap on spousal benefits. Divorced spouses and Social Security benefits. Social Security rules allow divorced spouses who are unmarried to claim spousal Social Security benefits if the couple's marriage lasted at least 10 years. An unmarried former spouse can collect up to 1/2 of the former spouse's primary insurance amount. If a divorced person had more than one marriage that lasted for at least 10 years, he's entitled to benefits based on 1/2 of the higher earning ex-spouse's primary insurance amount. A spousal Social Security benefit to an ex-spouse has no effect on the size of the benefit given to the beneficiary's current spouse. Also, unlike the case of the current spouses, the applying spouse does not have to wait until the ex-spouse applies for Social Security. As in the case of married spouses, to receive half of the former spouse's primary insurance amount, the applying spouse must be of full retirement age. If the spouse applies when younger than full retirement age, the same benefit reduction rules apply. Note that this entitlement ends as soon as the divorced spouse remarries. Survivor benefits. Survivor benefits provide long-term support to growing children, surviving spouses, and sometimes even older parents of deceased workers. Surviving spouses generally need to have been married for at least 9 months to qualify for the survivor benefits. This requirement may be waived, however, if the deceased worker's death was accidental, or the deceased worker's death occurred in the line of duty while on active duty in one of the uniformed services, or if the survivor had previously been divorced from the worker after an earlier marriage lasting for at least 9 months. In the case of a surviving spouse, if the surviving spouse and the deceased spouse at the time of death were both full retirement age, the survivor is entitled to 100% of the deceased spouse's benefits at the time of death. The survivor can elect to receive the survivor's benefits instead of her benefits, and so should naturally only choose survivor benefits if they are greater than the benefits that she would otherwise be entitled to. If the first spouse dies before retirement age, the survivor benefits may be slightly different, but are also based on the deceased spouse's primary insurance amount. If the surviving spouse is younger than full retirement age, she can wait until full retirement age to start receiving benefits, or to switch from her own benefits to survivor benefits, or she can start taking survivor's benefits as early as age 60. However, if the survivor does apply before reaching full retirement age, her benefits are reduced by an actuarial reduction based on a formula that's similar to the consequences of other beneficiaries taking Social Security before full retirement age. Note that no matter which spouse dies first, the survivor can always choose the higher of the two benefits. Boosting the potential survivor benefits is one reason why Social Security financial experts often recommend delaying claiming benefits until age 70, particularly for the higher earning spouse. Racking up 4 years of delayed credits not only boosts that spouse's benefit by 32%, it also increases survivor benefits permanently if the first spouse passes away. Children's survivor benefits are like those offered to surviving spouses. Children are eligible if they are unmarried and are under 18, students aged 18 or 19, or if they are disabled. Parents of deceased beneficiaries are also eligible for survivor benefits if they were dependent on the deceased. Children who are entitled to survivor benefits receive 75% of the deceased's primary insurance amount. A surviving parent is eligible for 82.5% of the deceased's primary insurance amount, while 2 surviving dependent parents can each receive 75% of the primary insurance amount. Surviving spouses who are ineligible for spousal survivor benefits due to being too young, but who are caring for children under age 16, can also be entitled to 75% of the deceased's primary insurance amount. The total that all the beneficiaries can receive is limited to the maximum family amount of 150 to 188% that we discussed earlier. In our final module, we will discuss the process of appealing a Social Security Administration decision on benefits, and we'll describe the 4 levels of appeal available to applicants.